Now, we can handle the banks. We've been doing that for a long time. We can certify the fraud of the banks, not a problem. Everybody here has done it. You've probably got bucket loads full of certifications and judgments already. Problem is, it certainly appears that the courts are in collusion with the banks. All right? Now, we're giving them some leeway here. It just appears to be. It appears that the courts can ignore all the rules, regulations, codes, statutes, the court's rulings and opinions. Sound familiar? It's clear that when we enter the courts, we have no rights. There's a reason for all of this. This is the way they were set up. And the bank, and seemingly with the assistance of the courts, just run right over us. And that's what happens every day in every courtroom. So let's see, who are the courts? Who and what are they? Maybe we can determine why they're acting this way and how we can stop them. These courts are administrative courts who gain their authority under Title V, the Administrative Procedures Act. All right? These administrative courts were established for the purpose of being the watchdog over the public officers and offices, so that if and when the private rights of the American people were violated, we have a place where we can go and adjudicate or prosecute our grievance against that administrative agency. That's why they were established. They were established so that they could cut through the quick, and that we could file or prosecute our claim or prosecute our grievance without cost and without all the time-consuming baloney. The administrative courts were designed to give the administrative court the power of legislation. All right, the power of the executive branch of government could then give them judicial power and authority. They've been authorized to disregard laws, case law, Supreme Court decisions, statutes, codes, rules, regulations, and to change policy. We see this every day. They do exactly what they were authorized to do. All right? They ignore everything. And here we thought rule number one was they could change the rules at will. Well, it's close. These administrative courts were just authorized or created as a fourth branch of government at the request of the Bar Association. And that we see every day too. They act like the fourth branch of government. Now the issue is, the system was designed for use by the American people, not against the American people. These administrative courts have jurisdiction only over administrative agencies. And only a real person, an American sovereign, can bring charges or can be the plaintiff in these administrative courts. All right? They were established as a vehicle for use by the American people to lodge and adjudicate a grievance against any administrative agency, and gave this administrative courts the power and authority to make the corrections without the lengthy process of introducing and passing legislation. We are wanting them to make the corrections. That's what we are doing. We are not trying to break down. We are not trying to overthrow. We are not trying to, we are trying to make the corrections. Thank you. And that's what these courts are for, to make the corrections. Charges can only be levied against an administrative agency by the American people. All right, and can not be used against the people. The people are always the plaintiff, unless they're operating in fraud. These courts were designed to make the corrections within public offices to make them more efficient and to hold agencies and officers thereof accountable for their actions. That's what we're looking for. That's exactly what we're looking for. We want these courts to operate the way they're supposed to operate. These are our courts. Once we get these courts to operate the way they were designed to operate, there will be no more foreclosures. Because we already have the administrative judgment that says the bank is operating in fraud. Our key, or our objective is here, to make these courts operate the way they're supposed to operate.